think we'll make a start. I'm sure people will carry on joining us. That's absolutely fine. Good morning, everybody. My name is Lee Davis. I'm the Chief Executive of the Chartered Institute of Patent Attorneys, and I'm really pleased to be chairing this webinar and to be joined by colleagues from the Department of International Trade and the Confederation of British Industry, and of course, experts from the world of intellectual property in the form of two CIPA Council members. This is the UK's first ever International Trade Week. It's a week that offers a series of events to help businesses learn more about selling globally, and for those businesses to then connect also with trade industry experts, such as IP professionals. When the week was announced, we at CIPA thought it would be a really good idea to use it to raise awareness of the important role IP plays in international trade, and also to help promote the UK's IP professions as experts in this aspect of international trade. I should add that patent attorneys work alongside trademark attorneys, who are represented by the Chartered Institute of Trademark Attorneys, and solicitors and barristers who have a focus on intellectual property law. IP is a global consideration for UK businesses, and the UK's IP professionals are really well placed to offer advice covering all the major international jurisdictions. We've got a mixed audience today. We've got representatives from businesses and we've got IP professionals. We really hope that there's going to be something of value in this for each of you. If you've got any questions or comments you wish to ask any of our speakers, then if you please pop those in the Q&A facility, I'll do my best to get an answer for you. So without further ado, let me quickly introduce our panel before we get on to the formal presentation side of things. We have with us Luke Jessop. Luke is the Deputy Director for Procurement and Intellectual Property at the Department for International Trade. Luke leads the UK's objectives for procurement and intellectual property in the negotiation of new free trade agreements. And previously, Luke managed DIT's trade policy coherence team and developed UK trade policy positions and negotiation strategies for free trade agreements. Before joining DIT, Luke held roles in the Foreign and Commonwealth Office and the Department for International Development. So big welcome to you, Luke. We also have Andy Burwell with us. Andy is the Director of International Trade and Investment at the Confederation of British Industry. Andy leads the CBI's work on international trade policy and how it delivers sustainable, inclusive prosperity for all. This involves working with the 190,000 or so businesses that the CPI represents, including CIPA, I'm very pleased to add, to understand how they can drive prosperity forward across the UK and working with government to ensure its policy supports this. Andy joined the CBI from the UK Civil Service, having an 11-year career across international trade and investment, business and national security. During that time, Andy spent 5 years in Hong Kong and China working with foreign investors and British businesses to support UK growth, and has responsibility for the UK regional offices in China, India and the US. So big welcome to you, Andy. We also have with us Gwilym Roberts. Gwilym is the Honorary Secretary of CIPA, and Gwilym is also it's probably his main job, the Chair of IP firm Gilbert and Strode. Gwilym works across the patent process, including IP audit and capture, IP filing strategies, and patent portfolio management techniques. He acts for a range of clients, including individuals, SMEs, universities, and spin-outs through to multinationals, and handles a broad and diverse range of cases before the UK Patent Office, the European Patent Office, and the World Intellectual Property Office. As well as being a visiting professor at Queen Mary University of London, Gwilym is the co-host of the CIPA podcast, Two IPs in a Pod, with me. We chat with entrepreneurs, creative people, patent attorneys, the occasional judge and others about how the IP system works in the interest of UK businesses. And it's if you're a patent attorney listening into this, or if you're a business listening to something that CIPA is doing for the first time, the podcast's well worth a listen, even if I only say so myself. Welcome to you, Gwilym. And then finally, we've got Alistair Poore, the current Vice President of CIPA, and Alistair will become our President on the 1st of January 2022. Alistair has an unrivaled breadth of experience across the IP professions, which he continues to employ working as a consultant for IP firm Mills and Reeve. A science and law graduate, he originally qualified as a barrister in the late 70s before going on to qualify as a patent attorney, a solicitor, and a trademark attorney. So when we talk about IP professionals, Alistair is all of those. Alistair is returning for a second term as CIPA President next year, having previously led the Institute in 2010 through to 2011, when he helped bring into being the then new professional regulator, the Intellectual Property Regulation Board. Alistair is the editor of the CIPA Journal and a leading figure in CIPA's work on trademarks and designs. So welcome to you, Alistair. Well, I got through all of that without too many stumbles, so I can stand down for a wee bit now and let my speakers do their work for the next 15, 20 minutes or so. Luke, it's over to you first for your view from the top of this mountain looking down, if you like.
Great. Thanks, Lee. Good morning, everyone, and thanks for having me at the webinar. I'm Luke Jessop. I'm the Deputy Director for Intellectual Property and Procurement in DIT's Trade Negotiations Programme. It's great to have this chance to join you all today and to say a little about the role of intellectual property in UK trade policy. Trade policy has certainly been a growth area in government over the last 5 years. Since the EU referendum, the Department of International Trade has been created out of the disparate elements of trade policy that had been left to the UK while we were an EU member, and has grown rapidly to fulfil its new responsibilities. Until last year, the focus of our trade negotiations work was very much on rolling over the terms of existing deals, which the UK had been party to as part of the EU, which we would have lost our rights under had we not agreed to continue those, and to prevent a cliff edge for UK firms when we left the EU at the start of 2020. Since then, over the last 2 years, focus has been on a new generation of deals tailored to the UK's needs, first Japan, then Australia and New Zealand. We started ascension talks with the Comprehensive and Progressive Trans-Pacific Partnership and announced our intention to begin further negotiations with India, Canada, Mexico and others. We've also stepped up our multilateral engagement and developed a clear and independent voice at the WTO for the UK. In total, the UK has already negotiated and signed 70 trade deals in the space of the last few years, a historic record for any country. I'm proud to lead the work of the intellectual property team on these agreements. The UK's new independent trade policy is a central plank of the government's ambitions for Global Britain, which is our programme of increased and deepened international engagement, aims to reshape the UK's place in the world following our exit from the European Union. The UK's ability to create, export and appropriately protect intellectual property is an essential element of this government's ambitions for the UK in that context, for us to become a science superpower with implications across our economy. Intellectual property rich and creative industries make a significant contribution to the UK economy and to economic growth. £64 billion worth of intangible investment in the UK was protected by IP rights in 2016. The UK's IP regime is rated as one of our high quality assets and is consistently rated as one of the best in the world. We believe our system achieves an effective balance between rewarding research and innovation and reflecting wider public interests, and that it provides a model for our trade partners to aspire to. In that context, our trade agreements provide an opportunity for us to promote our system to others and to encourage improvements that bring their systems closer in line to ours, creating improved conditions for UK businesses to trade and invest in IP internationally. So far, we've been primarily negotiating with countries whose systems are in some respects similar to our own. Nonetheless, we've had some notable successes. We've reached agreement in principle with Australia and New Zealand, where we've secured provisions on the treatment and protection of patents. For Australia, we've secured commitments underpinning the IP in our world-leading innovation sectors. And New Zealand and the UK have committed to IP provisions that will support our vibrant economies through adequate, effective and balanced protection of IP rights, including patents. The deal also enshrines New Zealand's current minimum levels of regulatory data protection for pharmaceutical products and agrochemicals, with no change in the UK's domestic systems. Going forward, we'll continue to seek to maintain our effective IP regime and look to improve others where possible, including patent protection and its enforcement. These agreements represent the first phase of an ambitious programme of new free trade agreement negotiations, and we expect to soon include negotiations with Canada, Mexico and India in that. But, of course, trade policy is not an end in itself, but rather a means to the end of greater prosperity for the UK. This will only be the case if trade policy delivers opportunities that are useful for UK businesses and professionals, and only then if they're empowered and inspired to make use of them. That's why DIT's engagement with private sector stakeholders is so important. And I'd like to thank CIPA for their high quality input into our consultation processes and our advisory groups, especially their active role in our intellectual property trade working group. Their perspective is really valued. An essential part of our policy making. It's also why sessions such as the one today are so important. It's great to see so many professionals meeting together to discuss such a relevant topic for our trade programme. And I'm sure the panel discussion and Q&A will simulate a lot of discussion and thought about future export opportunities. I hope you all enjoy the webinar, and I'll hand back to the chair. Thank you, Lee.
Thanks for that, Luke. And I just probably should note for delegates that I know you're on a hard stop at about 12ish, so we'll leave us around about then. So thank you for that. Andy, we're over to you now for your helicopter view.
Thanks, Lee, and Luke. That was a tour de force, really, of where the UK is and where IP fits within the kind of trade discussions and infrastructure. So it's a very good. I'm not going to speak for too long or repeat what Luke said, but just from a CBI perspective, IP really has been at the forefront of what our members care about when it comes to trade negotiations, working with Luke and his team, when it comes to market access discussions, obviously with the US trade deal negotiations going right, there's actually still a lot of state level market access work that can be done. IP has really been at the fore of those discussions, and not just IP, but also the role of IP professionals and the mutual recognition of qualifications for all industries. I suppose it's also worth thinking about kind of prior, I suppose, to trade, the contribution that IP does make to the economy. As Luke was saying, obviously it's a huge contributor financially, but equally for leveling up as well. Every firm across the country has IP one way or another, whether they recognise it or not. It's a huge driver of revenue for firms, but it also underpins our competitive advantages. If you look at the industries of today, the services industry is a really classic example. IP really does drive growth, and equally for manufacturing firms. But if you look at the integrated review, you look at the other strategies that government has on how to grow the economy to be competitive versus our allies, as well as other nations across the world. Actually, all those industries, whether it's quantum computing, whether it's AI, whatever it might be, really does rely on IP, does rely on trademarks to actually protect those competitive advantages as they are developed and as they grow and internationalize overseas. So it's not going to go anywhere. It's still going to be a core asset for UK PLC in 20, 30, 40 years, and in fact probably an increasingly important one. So it will really be at the fore of our discussions on international trade. Equally, it's kind of something which needs business to help and support other businesses, working with CIPA, etc., to help others understand the importance of IP. We're running at CBI something called Big Fish, Little Fish, which is about innovative companies and startups and SMEs talking to big business about how to collaborate and trying to demystify and educate a little bit that relationship both ways. And a big part of that is IP. A big part of that, little companies thinking that big companies are going to steal their IP and and run away with their innovations. That's not the case. But actually, there's a lot of education that needs to be done, particularly as we encourage big business to take their supply chains internationally with them overseas to increase exports. How does IP fit into that? What is the role of IP within that relationship between a big company and a small company? That is all tied in with the trading relationship as well. And the final comment I'll make is about the role of government within this. Yes, DIT, fundamental to developing trade agreements, to negotiating market access. But actually, we also need to coordinate within Whitehall all the different departments that have a role to play in this, whether it's BAYS, whether it's DCMS, whether it's DEFRA. IP and trademarks cover every sector, and that means every government department has a role to play, has a skin in the game in this. We need to ensure there's great coordination and cooperation between those departments to make sure that we can actually leverage to the greatest ability for the UK the role of IP and the benefits of IP and trademarks as we grow. I'll stop there, but thanks for having me again.
Thanks, Andy, and hopefully we'll have some questions for you later, or indeed you'll have the chance, because I know that you might have a question or two. You'll have the chance to ask some questions as well. So we move now to Gwilym Roberts. You're going to do us a whistle-stop tour through the patent system, I think, Gwilym.
I am, yeah. Thanks very much, and thanks first of all to government and CBI for their recognition of the importance of IP. It's great to hear. If I can echo one thing you just said, Andy, I think it's so important for all these different departments of the government to be linking up, as I'm sure you're endeavouring to do. Can I chuck in the Intellectual Property Office to that mix as well, by the way? Obviously, they're vitally important, and they've got that wonderful kind of global view as well, as we know, but that's for a different webinar. I'm conscious that our audience is a mix of IP specialists who want to hear about the government side, and maybe international traders who want to hear about the IP side. So it will indeed be a whistle-stop tour of the patent system, but with some comments more broadly about why it brings value and just reminding people just what a patent's for. So as we all know, patents are directed towards technical developments, and they give the innovator a monopoly. So as we all know, again, it gives you that incentive to innovate. If we didn't have patents, you would innovate, people would copy it, and you would lose all that R&D, and they would be able to reduce their prices because they hadn't made that R&D investment. So it's a long-standing balance between innovation and monopoly that's worked extremely well for hundreds of years. I had an interesting discussion yesterday with somebody about what would the world look like if we'd never brought a patent system in, and it would be a world of jealously guarded trade secrets and a very different place indeed. And we'll talk in a moment about the collaboration point there, Andy, which is a great one. So this monopoly that you get, this 20-year exclusivity for your invention, is a country-by-country thing, but one of the most important developments is the international system that we see. And without going into huge detail, this permits you to get that exclusivity in the countries you want to get, as long as you take the right steps in the early stages of the innovation process. And again, that's essential. And I would say that the international system that we have at the moment is one of the most global and harmonized international processes I think that's around. It's incredibly effective. A patent in one country will be as strong as a patent in another country. We have strong judicial systems around the world, and we have a good global knowledge of the importance of IP. So there is this wonderful IP international system underpinning export and global trade that I think is something that the UK needs to take absolute advantage of. It's worth remembering that the value that you get from your patent can come from a range of different directions. Of course, yes, it's this exclusivity, it's this barrier, and that permits you to sue somebody for copying your invention. If you can show it's an invention that they have taken the inventive concept, then you can get injunctions and damages, and this can be incredibly powerful. But of course, going to court isn't something that everybody wants to have at the top of their business plan. So often that is the role of IP there, is that's the final sanction if other areas don't work. One of the most obvious areas as an alternative is, of course, to license your IP. And let's just take a step back and think what that actually means. It means that if you, for example, develop a new process for, I'll anonymize a client here, a new process for developing battery technology using lithium and certain other materials that gives you extra battery capacity. There are various options to you for commercializing. Yes, you can make it and you can sell it, and if people copy it, then you can stop them through injunctions and the patent litigation process. But equally, you may take the view, we don't really have the capacity to make this a global business. We have the technology that other people with bigger manufacturing capability, for example, can implement. We want to license that technology out. So don't forget that when you talk about export, you're not just exporting products, you're actually talking also about exporting know-how. And the patent gives you the ability to define that know-how and negotiate deals based on that know-how, based on this clear-cut legal framework. That's incredibly important. And I think, as you said, Luke, for a science superpower that the UK hopefully already is and hopes to be more of, then that element, this idea of building this incredible technical know-how, but then having the mechanism for monetizing it globally is an incredibly important one, and based so strongly around the patent side. There are a couple of others that I'll mention quickly. There are strong tax advantages, don't forget, to having a good IP portfolio, and the governments want us to develop. So bear in mind that in the UK, there are things like Patent Box, but many other countries also have very favorable tax regimes. And this is not dodgy transfer licensing stuff. I'm talking here about governments really wanting to stimulate innovation by rewarding companies through tax breaks for their IP. Never forget that. The one that you mentioned, Andy, also is amazingly important, which is collaboration. If you have two companies who are both bringing something to the party, they need to know how they can balance the relevant inputs and how they can kind of control their input to it. And the patent system, again, by cross-licensing, gives you that collaboration opportunity. That's incredibly important and becoming of increasing importance. You only have to look at there have been successes and failures in the vaccine rollout, but many of the successes were IP underpinned collaborations between many big players. If it weren't for IP, it'd be very difficult for each one to work out quite what they brought and what they got out of it as well. And of course, investment for your new business, where you're an innovator, where you're developing early. People looking at investing in your business want to know how strong is your business model, and it's the IP that you have, the ability to have control over your technology, that is going to be a very important message to the investors. So a couple of other points quickly, Lee, because I know you want us to kind of keep this bit quite short. One of them, I wanted to just talk about the counter story. What happens if you don't protect your intellectual property? If you are an innovative company, if you are creating new technology, new brands, you have a certain look to what you do, or you've just the company that first brought an idea to market, then intellectual property is the thing that provides that first mover advantage. Otherwise, third parties will and can come along and take advantage of the work that you did to piggyback off it, and there may not be too much you can do about it. Now, IP is not a cheap option. You do need to go into the patent process, for example, with your eyes open as to the costs. It needs to be factored into a very clear-cut business plan, but actually in a good business plan which takes into account the realities of building manufacturing capability globally, of the marketing and other related aspects, the IP part becomes quite a small part, but incredibly important. So don't go in with your eyes closed, recognize there are costs attached, but make sure that in the context of the bigger business plan, the IP works, and that actually is the way to make sure that it fits in properly with the strategy. And one final comment, wonderful work by the government there on the free trade agreements that we're getting and the role of IP in that. And thank you very much for identifying that the patent attorney profession has been feeding in. The UK, this is a quick sell. The UK patent profession is quite big. It's the second biggest in Europe. And it is globally recognized for its excellence. We have judges who have an incredible experience. We have a litigation process. We have an incredibly well-developed tech transfer function as well. The UK service sector on IP is wonderfully strong and absolutely globally oriented. That's how we're trained. So one of the lovely resources that government has is actually a fantastically well-resourced and well-educated service sector on IP. It's so important that we're part of this kind of concept of making in the UK and selling to the world. Thanks, Lee.
Thanks, Gwilym. So not a difficult task, Alistair. You need to follow that for the rest of the IP system by taking yourself off mute.
There we go, different approach from teams. I would like to echo, first of all, Gwilym's comments about the appreciation, the engagement between DIT and the IPO in relation to the international aspects of, particularly the international aspects at the moment of intellectual property. And then I want to jump off the rails slightly, because Gwilym has sort of implied that the only bit of IP which is really relevant is this patents bit, and has talked very esoterically and fluently about how important the patents bit is. But I'm going to go back first to one of the things that he talked about, which is protection. Unfortunately, I can't put any slides on the screen, or I haven't got them together yet, but I want you to visualize having an Aston Martin and parking your Aston Martin out in some suburban district of one of the cities in the country with the keys in it, and thinking, oh, well, that's fine. When I come back, it'll be there. And I don't want, I think actually that might be a little bit unkind on any particular chosen area of the world or this country to isolate that. So I'm going to tell you a little anecdote about one of my clients who, actually this was a patented invention that had been made, designed screens for putting over windows in housing estates so that people didn't break into them while the properties were empty. And the party who had invented these came out to the local authority in question in order to demonstrate them on one of the sites. And they put them in there, and they came back confident that there wouldn't have been any break-ins into the particular property, and parked their car outside. And they demonstrated really well how brilliantly this invention worked, and came out and found that their car didn't have any wheels anymore because the wheels had been stolen. With the Aston Martin, that might not happen quite so obviously. It's a bit ostentatious for somebody to walk off with the Aston Martin. It might be spotted. They might want to flaunt it and make it very obvious, but it would be really irritating if it was stolen. So actually, you don't leave it out there. Now, the same thing applies to intellectual property, except that quite a lot of intellectual property you don't even get to protect or say you own until you, as it were, have the keys of that intellectual property. And so what I want to give you is a few tools to talk about in the broad sense, and it applies to the patents just as much as anywhere else, to tell your boss, your stakeholders, your investors, your collaborators, to demonstrate that actually you value the intellectual property and you can make use of that intellectual property. So in summary, IP actually matters, how the protection works. There's help out there. We've already heard from Luke about some of the help that there is, and the CBI, and the Intellectual Property Office also have tools, and of course the intellectual property professionals, and I'll come back to that in a moment. The UK has a strategy which depends, at least to a significant extent, on the development of strategy and development of business and innovations around the world, and the excellence that the UK currently has in the area of innovations. And so I thought it would be worth talking a little bit about the overall aspects of intellectual property. Trademarks are much more familiar to most people. You know all about brands, and quite a lot of people will know about trademark registration. So you register a trademark in respect of certain goods or services, and you can get that protection all over the world. There are international arrangements which actually are remarkably well harmonized across the world. There are a few glitches in some countries, most notably the United States, and to some extent in places like China in relation to it. But actually, it's a straightforward exercise. It's probably best to obtain some sort of professional advice. But it does cost money in order to do it, and it costs a lot of money in order to do it in every jurisdiction. So you say, or your boss or whoever it is says, well, what are you doing spending all that money? Or alternatively, you have to justify why you would spend that money. And for trademarks, you can look at the cost. You don't have to do it immediately. Unlike patents, you don't lose your opportunity, at least not unless somebody else steps on your toes beforehand. So it's not quite so critical about time. And you can take a fairly strategic approach about where you want to file your trademark protection in order to get adequate protection. So it may be high-risk jurisdictions that you want to look at. Some places like China, where you may not be able to manufacture and export your products if some pirate has decided that they're going to register your trademark in that country. And historically, it was really very difficult to get rid of those trademarks, thanks to a lot of work from governments around the world, including the UK government, the IPO, the Chinese Intellectual Property Office is now making it much easier to get rid of trademarks which have been filed in bad faith. But still, it is a real obstacle, and you can lose a lot of time and money in the process of trying to get rid of it. And you can consider which jurisdictions are the jurisdictions that you would actually expect to be marketing in due course, or if you didn't market in due course, if you did market in due course, you would really mind if you couldn't use your own trademark there. So all of that really goes about designing a strategy, and I'll come back a little bit to that sort of thing in a moment. The same sort of issue applies to designs. Designs are a little bit more complicated. They're designed to protect the shape and appearance of an article, or the shape, appearance, pattern, or configuration of an article. And you can get them on an unregistered basis or on a registered basis. But if you want to use it for investors or for the benefit of demonstrating to your stakeholders that you actually value the intellectual property in it, or if you want to use it as a deterrent for third parties, actually registration of designs is very much preferable to not registering the designs and relying on some other form of protection. Designs also are much less uniformly handled through the whole of the world, although registered designs are moderately uniform, and there is an international convention which allows you to file international design applications, although you need to understand a bit more about it. And designs can be filed perfectly easily by any individual simply producing a drawing of their design and registering it. But there are strategic issues around doing that. And one of those is what I would describe as the trunky effect, which was the trunky, which you may know are those little suitcases on wheels with decorative animals as part of them. You drag your children through airports on in order to keep them a little bit quieter. And they, through a series of events which were not entirely under their control, some of which was that they had put on the market something rather earlier, which was a simplified design, ended up with relatively narrow protection in relation to those designs. If they had had advice and followed it, professional advice and followed it at a much earlier stage, they very well might have obtained considerably stronger protection. But the trunky case has led to, sorry about the pun about the trunky case, the trunky case has led to some reservations about people thinking about whether design protection is really worth filing. And it's very interesting to understand that, in fact, in many cases, I would say registered design protection is vastly underused. And I can give an example in one industry where there was essentially 4 or 5 major players in this industry. One of them had design protection for just about every product that they produced, and usually several designs for every single one of them. One of them had 2 or 3 registered designs, and one of them had no registered designs. And most notably, the one who had large numbers of registered designs, I went along Canal Street in New York, and I couldn't see any of their products on sale. And it was part of an overt strategy of enforcement, which was much more robust in relation to all of their designs and trademarks. So people have different approaches to the way that it's done, but I think it's often very much underused. And where one is thinking of a country which has a real reputation in innovation and design, and where the quality of the design is also one of the things which makes people, I trust products which originate from the UK, I think it's really valuable to focus on that sort of protection in order to obtain obtain the advantages of keeping other competitors out, or stopping your distributors thinking, oh, that's really quite a good idea to do something. And I can give a couple of examples of the sort of things which I've experienced which have been really effective. One of them was an exhibition installation. This was actually a US client who manufactured products which were used for erecting exhibition stands very quickly and efficiently. And it was too simplistic really to be able to get sensible patent protection for, but we could get registered design protection for it. They marketed it, they promoted it throughout the world, but they essentially had most of their business in the United States. And then they discovered that somebody was importing products from Australia to the UK, which were almost identical to theirs. Rather than taking them to court about it, it was just a case of writing them a letter. We wrote them a letter. The client got in touch with them and eventually ended up with a deal where the Australian client bought the products from our client instead of purchasing ones which had been manufactured in China. Another example, and this comes back in a sense to the pace of development and getting the market first, was one where sports equipment being designed and was being manufactured by a client of ours. But before it actually got onto the market, it discovered that somebody was importing from China identical products to theirs. They had a registered design in place, so that was okay. And we ended up by using, this is not very sustainable, by using a steamroller to destroy large quantities of the stock that were imported into the UK. But both of those are really good examples of the power of intellectual property protection generally before you get to the point of enforcing it in court. That actually just having that registered design in many cases, and the same is true of patents, was what you needed to be able to negotiate your deals with your distributors, to ensure that you could enforce the rights in certain jurisdictions to stop yourself being blocked by pirates who might want to get in the way. So fundamentally underlying that is that one needs to have some sort of strategy. All of these intellectual property rights are complementary to each other. And what you need to have is a strategy understanding both how you are going to protect your intellectual property rights, or understanding what intellectual property you have, how you're going to protect your intellectual property rights, and how you're going to enforce or authorize other people to use those rights so that you don't end up in some sort of a mess in the future. And going back to what I said earlier, the answer to the bold question really is IP matters. The protection does work. There is help out there. As I've said, the DIT provide not only individual assistance, but they provide courses and things like that. There are other professionals. The Intellectual Property Office also provides work. And I don't want to repeat what Gwilym said about promoting the Chartered Institute of Patent Attorneys, but keep them in mind as a source of potential advice on how you can protect yourself internationally. Excuse me.
That's your 30-second warning, Alistair.
That is all I have to say on the subject.
Well, what a fantastic opportunity for me to butt in then. I was looking for a way to butt in. That was brilliant. So we've got 20 minutes or so for some questions. I know that Andy said that he might have a question or two to ask. So I'm going to give you first dibs if you want, Andy. Have you got something that you want to bounce off Gwilym and Alistair?
Yeah, happy to. Look, I think China is maybe an interesting place to start for those listening, because I was interested about the development of the Chinese IPO and trademark system, how it's getting easier. I remember when I was out there, companies coming into the market and kind of really struggling with that trademark question, finding businesses had in bad faith registered their trademarks, and then basically having to find a Chinese speaker to pay them off around the back door. How has that in kind of tangible ways actually changed for businesses? So if you are a company on this call and you are looking to export to China and you come up with challenges, what's now the structured approach? Should you go to DIT? Should you go to the British Chambers and speak to other businesses about how to get around it? What's the best way, would you say, for companies to really address that challenge? Because it still is a challenge, if we're honest.
The best way is to register your trademarks before somebody else registers them. So if you anticipate doing business in China or having manufacturers in China, make sure you get the protection. Talk to the intellectual property officer about it. Talk to other potential businesses who've done work in China, and just see why it really matters. And there are quite a number of examples of people who find that their export chain has been disrupted because their supply chain has been disrupted because the exports have been impounded at the port of export. And talk to the Intellectual Property Office about it. The changes, there are some significant changes in the law, and one is always a bit skeptical in China as to whether those changes in the law have been implemented. But there have also been a number of successes of cases brought more recently, which have been publicized from some of the big names about trademarks which have been filed in bad faith. So I think that there is a degree of confidence that you can have. But the short answer is register straight away.
If I can just add on to that, so as you say, the IPO is actually a surprisingly useful source of information on this, because they have the China attaché, so they have specialized advice there. I think in the end they will put you in touch, or suggest you get in touch with local legal advice. So there's some UK firms that actually operate out there as well. As Alistair says, the story has got much better. So I was going out to China for many years, actually, sometimes with IPO and more generally on business, and you could see the IP landscape changing there. China wants to become a global player. It wants to play the same game as everyone else, and so the enforcement has got far better. The bad faith point you mentioned is probably one of the kind of the worst elements of it, that's kind of still to be dealt with perhaps fully. On the patent and aspects like that, now you can actually get good support out there. It's always going to be difficult running litigation that far away from home. but it's become much more streamlined, and you will get a fair crack of the whip from the courts.
There's an underlying difficulty which is worth highlighting in China, which is again being smoothed over to some extent, which is if you ever get to the point of bringing a claim, the way in which you have to approach evidence is much stricter than it is in the UK or most other jurisdictions. And in particular, you often have to get your evidence notarized. So if you want to do a trap purchase or something, or you want to prove that somebody is applying the trademark, you actually had to get a notary to go along and do the trap purchase for you, or you certainly did use until recently. I think it is slightly modified now, but it meant that it was that much tougher to get the evidence that you wanted, and usually took rather longer.
Graham Farnsworth makes an interesting observation in the Q&A panel about the role of British embassies in supporting British industry abroad, and also Gwilym, you touched on it, but also the IP attaché network, which of course is whilst sort of limited in number, is an attempt to spread this support around the globe in the jurisdictions where it's important for the UK to be developing business interests. So thanks for that, Graham. Andy, anything else before I go over to the rather kind of niche technical questions I've got?
Let's go to the niche technical questions. And there's a couple of questions in the Q&A as well.
Okay, let's go to those. And so the first one was about exhaustion of rights. So I'm probably going to be looking at Alistair for this, because I know that's something he's had a look at recently. So the question is, Alistair, where do you see the UK's exhaustion of rights regime ultimately ending up? For example, for businesses looking to make use of the UK's SPC system, there could be significant disadvantages under an implied license regime as compared with the EU EEA systems when it comes to imports from EPO states without SPC protection after patent inquiry, e.g. Turkey. And when you're giving your answer, if you can just explain what some of those initialisms are for people that might not be otherwise familiar.
Well, I might leave Gwilym to do some of that on the SPCs and patents. So SPCs are supplementary patent protection certificates, which broadly speaking, people think of as being protecting the post-expiry period of patent cover for normal patent cover for drugs. Where would I expect it on trademarks and designs? Sort of pretty much where we are at the moment, I think. I was contemplating asking a question about that. Currently, there is this concept of UK plus, which some people describe as EU minus, which means that if the UK export to the EU, they don't recognize exhaustion of rights in relation to a trademark which has been applied in the UK. On the other hand, if somebody exports from the EU to the UK, then we do recognize trademark exhaustion in respect of goods which have been first put on the market in the EU. So it's an asymmetric process. The argument is it arises inevitably out of the Northern Ireland Protocol, and there's nothing much we can do about it. Quite a lot of arguments have been put forward by a large group of intellectual property practitioners, both the intellectual property bar, the intellectual property solicitors, CIPA, Stable IP, that actually that particular argument about the Northern Ireland Protocol is wrong, and it would be practical to apply effectively a border between Northern Ireland and the Republic of Ireland in relation to trademarks and designs. But that's a bit of an open question, I think, still at the moment, and particularly since the Northern Ireland Protocol is rather a sensitive political topic just at the moment. On SPCs and patents, I think I will leave it to Gwilym, because there's also a complication about marketing authorizations and things like that, which makes it a slightly more bizarre area.
Hey, Gwilym, before you give your highly technical answer, can you explain in simple terms what exhaustion of rights is?
Okay, yeah, that's always a challenge, isn't it? It's basically, this comes down to what selling something when you own a patent on it means. And roughly speaking, if you have a patent on the product and you sell the product, then somebody who then gets the product, whatever they do with the product, they're free to do. They're not infringing your patent, which is actually may sound really obvious, but it's the sort of thing that's not always that clear from the way the law's written. What can happen though is if you sell in other territories, it's possible that that may or may not be the case once it goes abroad and then comes back into your territory. And what that can do is it can lead to price disparities as a result. And this can be a real concern. And any asymmetry in particular, as the question picks up, can be an issue. I won't give a technical answer because I think really we're just waiting to see what the government says. And I know Luke had announced he had to go, but I swear blind he clocked off the moment that question appeared. But I think we're waiting on the consultation that Alistair mentioned to come back. This asymmetry is potentially a problem. Everybody has made the concerns clear to government, but the government is, as Alistair says, potentially rather fettered by some of the other consequences of leaving the EU. And well, there you go. It's a classic, probably unintended consequence, but yeah, let's not suggest it's solved or isn't a problem, is what I will say.
Cheers, mate. Andy, have you got that? The CPI, does that have a position on this potential asymmetry, and is it done any thinking about the whole Northern Ireland Protocol and its impact?
Just a tad, yeah.
No. I thought you might have.
I'll put my hands up here. I'm not an IP expert, so I'm not sure I can fully qualify CBI's full position in this space, but it will reflect industries at the end of the day. So actually, what Gwilym was just saying, and Alistair as well, it will be common across businesses, across our members, and not just across CBI, but other business organisations as well. I think there is quite a common voice around both the challenge and the need for a solution. And it's something which, as we've talked about earlier during this session, with the importance of IP to our economy, something which needs to be addressed and answered as soon as possible. Obviously, Northern Ireland, there's a lot more going on at the moment with Article 16, etc., and a lot more concerns around that. So obviously the government is slightly distracted in various different ways. Let alone with COP26 and other things happening in Parliament. But fundamentally, this is a really important issue, which isn't going to go away, so needs to be resolved. I think it's an interesting point around, more broadly, not just Northern Ireland, but internationally, the importance of alignment to the European Patent Convention, and actually just broader not kind of bastardizing the term here, but asymmetries to that current system. And actually, when you look at CPTPP and the other negotiations the government's going through, a key concern for industry is actually just maintaining some commonality and that closeness to the EPC as a nation going forward, because the EU is a rule setter. It is on patents. It is on data flows. Actually, the US recognizes that. The UK needs to recognize that as well, and we need to have that harmonization to ensure that we can maintain our competitive advantage.
Well, Gwilym jumps in and says, I will make the point, of course, that the EPC is not an EU instrument. It's a much broader treaty than the EU has coverage, but we use these words European interchangeably. And your point is really well made, Andy, and one that's been exercising us as the government's gone on its various forays around working out its place in the world in terms of trade. We've been keeping a very careful, watchful eye on this. We've been spending time explaining to government the value of the EPC to the UK business infrastructure, both in terms of UK businesses being able to access the EPC and what it means for them, and also the value, the monetary value that the UK profession brings into the UK in terms of work that comes through the UK profession and into the EPC. So the point you make is a really well made one. Alistair, Gwilym, do you want to add anything to that?
I was just going to add, I think IP is one of the many babies that could be thrown out with the bathwater of all these negotiations going everywhere. And I think actually Luke, in his comments, made it clear that it is now high up on the agenda, which is incredibly important for the UK to be this export power, which I think it can be, and to be a science superpower, which I think it absolutely can be. Not only do we have to kind of understand IP, but we also need to be pretty compliant and fitting in with the global regime. And for anyone who is thinking, is there another way? Is IP perhaps not the right way of doing this? You don't have to look beyond China, which has quite clearly set its sights on becoming a global economic superpower and is doing rather a good job of it as well. and the efforts it has put into not only developing its own IP system, but also being compliant globally with IP. It recognizes it. We're not the only country looking at how to kind of position ourselves in the world from different position. I think that message is really strong. And also, you look at the US, who really understand IP, they've got it baked, and just what a powerhouse that makes them as well. So I think the government is recognising IP is important, but I totally agree, Andy, it's got to keep this really high up the agenda, and the UK position's got to be really, really clear cut.
Yes, I would entirely agree with that. And I think one of the fundamentally important things is that currently the UK is very influential in the intellectual property field. But things like the European Patent Convention and the European trademark law is being largely adopted in a very large number of countries. And there is a real danger that if the UK diverges significantly from those, it will lose its influence. And its influence is part of the basis of trust of the UK as being a really trustworthy country to do business with. And that's something which it would be all too easy to lose, and is really important to ensure that the government is very focused on maintaining the trust in the UK's intellectual property system, and therefore alignment and influence in where it goes in the future.
Alistair, can we stay with you? And I'll now chip in some of my pre-prepared questions that I had, just in case we needed some to fill at the end. We've got sort of six or 7 minutes. So as we've been talking about things European, how are IP rights affected by Brexit in terms of your lens, trademarks, designs?
Well, the principal argument has really been around the issue of asymmetry and exhaustion of rights. So the ability for EU companies or EU products sold on the EU market, services supplied on the EU market, to be exported to the UK, which has some significant impact on the way that you might set up your distribution arrangements and where you might set up your distribution arrangements and things like that. Otherwise, I think that for a large part, the difference is that you have to obtain protection in the UK as well as obtaining protection in the EU. And there is a possibility, but I think it's relatively unlikely, that people will say, well, we only need to obtain protection in the EU. We don't need to worry about the UK, because historically that's been probably the case anyway. Trademarks are much more important on a national basis. In some respects, patents, you can afford for some of them to be filed in some key jurisdictions, not elsewhere, but trademarks are much more likely to be required in all the jurisdictions where you think that there might be an importance in having them.
So if I've got an IP portfolio, I think the important takeout for me there is that when it comes to patents, the system hasn't changed. European Patent Office, not part of the EU, carries on as normal. Everything is as was before. The European Intellectual Property Office, which is the bit that deals with trademarks and designs, is of course part of the EU. And now there is this kind of parallel sense of protection in the UK, protection in the EU.
That's absolutely right. And a number of UK firms will have offices in the European Union and be able to apply for, or technically prosecute, trademarks before the European Union Intellectual Property Office. Anyone can apply for them effectively. But if you need to deal with the European Union Intellectual Property Office, you have to have somebody who is a practitioner in the main part of EU in order to correspond with them. That remains the case, that some EU practitioners or firms have practices there, so they can do that. And quite a lot of firms have made arrangements so that they can do it via a correspondent firm in the EU. That does make it significantly more complex for somebody to understand exactly what their strategy in terms of using professionals might be in relation to trademarks. The designs area is a great deal more complicated, because some of the similar things apply to registered designs, but unregistered design rights have been turned into a quagmire of different rights, which people may or may not know whether or not they're going to take effect in the EU or the UK at the same time, or in one or other of them, so that it's a significantly more difficult area to deal with.
Can I bring us back to very basic principles now, if that's okay? Because some people listening in now, and maybe even listening back to this in the future, because we'll hopefully make this as a resource available to people that that weren't able to attend today. Let's say I've been in business for a little while. I worked out early on that I had something that was worth patenting, so I've got a patent. Got it a few years back. I've got my brand, so I've got a trademark. But I've listened to a webinar like this, and I now realise that IP is far more complex than having a patent or having a trademark. Is there a quick and easy way of identifying how much IP there is in my business?
I might pass that on to Gwilym, but I think the answer is not a quick and easy way. Although you can get assistance, you can get audits done. There is, I think, still a grant program to have audits done by IP professionals, which is funded by the Intellectual Property Office, or originally by their sponsoring department, I suppose, in order to have an IP audit carried out. Or you can go to any intellectual property professional, ask them to carry out some sort of IP audit, or a number of other professional firms which do it. But it's really quite difficult without understanding exactly what intellectual property is, because it's an intangible right, as it were, to direct somebody to, this is the way that you go about protecting it. I suppose that you can identify the key elements like information, names of products or services, and say which of these are ones which actually you would really be pissed off if somebody else started using it. When it gets to patents, it's probably the information that you have, which isn't in the public domain. What have you got there, which actually somebody would like to know, your competitors would like to get their hands on in order to be able to design something? Or what are the future products or ideas that you have, which if you let them get out into somebody else's hands, that would be really irritating. And that would be quite a good starting point to go then to a professional to say, can you tell me which sort of things I ought to be protecting here?
Can I jump in here?
Anything to add? Go on, Andy.
I agree with everything Alistair said. I think there's a point here that some people might be scared and frightened of doing it because it sounds so complicated and so difficult. I think there's a really key point here that actually, with the patent box and with various other tax credits, it's actually, yes, an investment up front, but that investment is actually something which will be returned to you through other benefits later down the line. So it's really worthwhile doing this, not just to protect your business, but actually it makes financial sense as well, even though it does seem scary and does seem expensive.
I think I can also go back to the Aston Martin example in a sense. And is there something that you would be really irritated if somebody else got their hands on, or worse still, would damage your business if you didn't, if they could get their hands on it? Or are there things that you would really like, avenues of development that you would really like to follow, which you would want to be able to stop somebody else copying you on?
My only other comment is that the IPO, as part of the new government innovation strategy, they're actually augmenting the audit process. So it has been identified as something of real interest. I think it's there already, and it's going to become even more powerful. It is complex and daunting, but actually, yeah, it's not as complicated as it sounds once you get going. And I think once you've got the framework in place, which can be very simple, continuing it can be easy.
So just one final one, and it follows on from that really. Alistair used the phrase IP rights are intangible assets, but they have value. And is it right that firms, businesses can leverage that value in terms of borrowing and using that to invest in their businesses?
They can certainly obtain investors for doing it, and in some cases they can borrow on the back of it. It tends to be rather more, you tend to require rather more of a track record for the underlying intellectual property right in order to be able to borrow on the back of it. But there are quite good examples. I think Amstrad is one of the examples, and I think Sinclair is another, where the intellectual property rights had actually been really valuable in terms of the security that the banks had at the time that these companies ceased to be solvent. And there is much more interest in lending on the basis of intellectual property rights now. So yes, identifying intellectual property rights clearly and having a strategy which allows you to do that, and showing that you know the value of those, or you know what they contribute to your business, will form a basis for you to be able to go to somebody and say, actually, can you lend us some money, or can you fund us on the basis that we've got these intellectual property rights?
There's a really good example of this, very simple, UK export finance. People haven't engaged with the UK, if they should do, they will support and guarantee intellectual property. Very simple.
It's a great pointer to end on, Andy. Thanks for that. And maybe we can flick around the little link for people who've been on the webinar. So to Luke in his absence, thank you very much. Andy, Gwilym, Alistair, thank you, the three of you, for your input, which has been hugely valuable. I'll just finish up with a throwaway comment, and that's that Alistair's mentioned often enough during this webinar about the risks of leaving your Aston Martin in a place where it might come to some kind of loss. Fortunately, I drive a beaten up old Jag with a broken down flywheel. I can leave it anywhere I want. No one else can start it apart from me. Thank you all. Hope you've enjoyed the webinar, and it'll be available to access, I'm sure, on the CIPA website on after this. So if you've got friends or colleagues who would have benefited from it, please feel free to point them in our direction. Have a great rest of your Friday. Bye-bye.